Hello and welcome to this week's SCC Online Weekly Rewind. I am Bhumika Indulia and this week I have got for you Karnataka High Court's important ruling on marital rape and some interesting pronouncement by Supreme Court, High Courts and some top legislation updates. So stay tuned. In today's top story, I am going to discuss the marital rape case, where Karnataka High Court, while observing that the court practices discrimination, remarked that a woman being a woman is given certain status. A woman being a wife is given different status. Likewise, a man being a man is punished for his acts, and a man being a husband is exempted from his acts. It is this inequality that destroys the soul of the Constitution, which is right to equality. The Constitution recognizes and grants such equal status to women as well. Read our full story on SCC Online blog. Coming to the Supreme Court. The compensation in case of death occurred due to COVID-19 is now to be claimed within the prescribed time limit, as the Supreme Court has now fixed the outer limit of 60 days from the date of the order, that is 24th March 2022, in case the death occurred due to COVID-19 prior to 20th March 2020. For future deaths, 90 days time is provided from the date of death due to COVID-19 to file the claim for compensation. However, the earlier order to process the claims and to make the actual payment of compensation within a period of 30 days from the date of receipt of claim to be continued. The court also directed a random scrutiny of the 5% of the claim application for ex gratia compensation of Rs 50,000 in certain states, and has said that if it is found that anybody has made a fake claim, they shall be liable to be punished accordingly. The bench, comprising of Indra Banerjee and J.K. Maheshwari, has given split verdict on the issue as to whether the special court is debarred from taking cognizance of an offence under Section 23 of the Protection of Children from Sexual Offences Act 2012 and obliged to discharge the accused under Section 227 CRPC only because of want of permission of the jurisdictional magistrate to the police to investigate into the offence. The case relates to a news report published in the newspaper Karavli Manjavu regarding the sexual harassment of a 16-year-old girl, wherein her name was disclosed. The editor of the newspaper filed an application for discharge under Section 227 of the CRPC on the purported ground that an offence under Section 23 of POCSO being non-cognizable, the police could not have investigated the offence without obtaining an order of magistrate under Section 155 Clause 2 of CRPC. While the Karnataka High Court held that non-obstant provision of Section 19 of POCSO overrides the provision of CRPC, including Section 155 in the light of the split verdict by Division Bench of the Supreme Court, the matter will now be heard by a larger bench. Holding that the chairman of Central Administrative Tribunal has been conferred the power to transfer a matter from one bench to another on his own motion without any application from any party. The Delhi High Court agreed with Solicitor General Tushar Mehta that the power of the chairman of CAT under Section 25 of the 1985 Act is purely an administrative power to transfer cases. The court also observed that it may not be wrong to hold that the administrative powers are akin to the power of master of roster, who alone has the prerogative to constitute the benches and allocate cases. Read our full report on SCC Online blog. While addressing a matter surrounding the issue of cruelty by wife, the Delhi High Court has expressed that it has repeatedly been held that the acquisition of unchastity or extramarital relationship is a grave assault on character, status, reputation, as well as the health of the spouse against whom such allegations were made. The bench also stated that the said acquisitions causes mental pain, agony, suffering, and tantamount to cruelty. Calling it to be a moral policing, the Kerala High Court addressed a matter wherein a man had taken a lady from another community in his car, due to which mob attacked him with deadly weapons. In this case, the bench observed that if such a case would be quashed on the ground of settlement, it would send a wrong message to the public. The Ministry of Power has issued guidelines for the procurement of battery energy storage systems in the generation, transmission and distribution network of energy. With joint efforts of both Ministry of New and Renewable Energy and Ministry of Power, who have been working on this to provide a roadmap for the installation of the energy storage system in the country since last year. It will provide a push for India's energy security. The central government has given a state-owned Solar Energy Corporation of India for calling expression of interest for setting up a 1 gigawatt-hour grid-scale battery storage system. The central government has made the Foreigners Amendment Order 2022 in order to amend Foreigners Order 1948. The amendment inserts a provision for requirement of holding a valid passport or other valid travel documents while living in India. ESIC eases conditions for women to claim sickness benefits. It provides that in case of an insured woman who is in receipt of maternity benefit and due to the reason which a shorter contribution period is available to her in the contribution period in which the maternity benefit falls, she shall be qualified to claim sickness benefit in the corresponding benefit period if the contribution in respect of her was payable for not less than half the number of days available for working in such contribution period. Thank you for watching this episode. Stay tuned to our next weekly Rewind episode.